How does the affidavit deal with the possibility that maybe she, waived her right to a jury trial somehow?
She tackles that head on. She argues against any suggestion that you have to demand a jury trial using some specific form or document, especially if the court is simultaneously saying, you don't even have that right in the first place.
Right, that sounds contradictory.
She calls it induced waiver, saying, which is no waiver at all. Her point is, a real waiver has to be knowing, voluntary, and intentional. Courts can't just assume someone waived a right if they didn't clearly say so.
You can't trick someone into giving up a right, essentially.
That's the essence of her argument, yes. Right. It has to be a conscious choice.
And then there's this phrase, judicial economy. You hear that sometimes? The affidavit seems to really take issue with it.
Oh, definitely. This is a major point for her. Apparently, the opposing attorney, Joshua Leach, used judicial economy as a reason to deny the jury trial.
Okay. Like it's more efficient not to have a jury?
That seems to be the implication she's fighting. She contends the term does not appear anywhere in the Constitution. She calls it a court-invented phrase used to justify expediency over due process, efficiency over lawfulness, and administrative control over constitutional compliance.
Strong words.
Very. She goes so far as to call it evidence of judicial corruption and argues any ruling based on that idea is void for want of jurisdiction.
Meaning legally invalid from the start.
Yes, as if the court didn't have the proper power to make that ruling in the first place because it was based on an illegitimate reason, in her view.
Now, courts do talk about judicial economy, don't they?
Oh, right.
I mean, in general sense, managing caseloads and being efficient.
They absolutely do. It's a real consideration for courts dealing with, lots of cases. They need to keep things moving. The tension, and what this affidavit highlights, is that balance between efficiency and fundamental rights.
Right. Where do you draw the line?
Exactly. Her argument is that in this instance, that line was crossed and efficiency was prioritized over her constitutional rights.
Okay, so the argument then moves to the type of court itself, the jurisdiction. What's the point being made there?
Right. She focuses on the Seventh Amendment, the right to a jury trial. She quotes it. In suits at common law, where the value and controversy shall exceed $20, the right of trial by jury shall be preserved.
Preserved.
Yes. And she defines preservation, based on older case law, as keeping safe from harm, avoiding injury, destruction, or decay. So an active protection of the right.
And she questions what kind of court this actually is.
She does. She asks why the Blount County Circuit Court, which she says has called itself a court of record and a court of equity, seems to be acting like a court of chancery just for her case.
What's the difference, and why does it matter for the jury trial right?
Well, historically, courts of law handled common law cases where juries were standard. Courts of equity or chancery handled different kinds of disputes, often without juries, focused on fairness rather than strict legal rules. Her point is that the U.S. Constitution, Article 3, covers all cases in law and equity, and it doesn't carve out an exception for divorce or domestic relations.
But the opposing counsel cited an old case.
Apparently, yes. Joshua Leach reportedly cited an 1837 Tennessee case, Richmond v. Richmond, arguing the jury right didn't apply to divorce back then.
And her response
is pretty direct. She states, judges make rulings, not law. Case law is not law. Therefore, law is only created by the legislative body as codified in the Constitution.
Wow, that's a fundamental challenge to how common law systems usually work, isn't it? Saying case law isn't law.
It's a very strong, almost purist view of legislative supremacy. Usually, case law is seen as interpreting and applying the law enacted by the legislature and the Constitution. She's arguing here that jurisdiction should follow the substance of the dispute, which involves money and rights, like common law, not just the form or label of divorce.
Okay, so beyond the jury trial, she levels accusations about abuse of power, particularly around money. Let's go back to that taxed issue.
Right. She claims Leach's move to have costs and fees taxed to her is actually illegal taxation without representation by the court for asserting rights.